questions for oral answer. I declare the House... Order. I declare the House in committee for further consideration of the Policing Shortage of Youth Particulars Amendment Bill.
Speaker.
Mr. Chairman.
Order. The House and Committee on the Policing Storage of Youth Identifying Particulars Amendment Bill. We are on Part 1, and when the committee last considered the bill, David Clendon had the call and he has 4 minutes remaining. David Clendon.
Mr. Chair. Thank you, Mr. Chair. Yes, before the lunch break I was making some points about the purpose of the bill, Part 1 of the bill, and would wish to continue briefly in that same line. The point's been made a number of times that there's no evidence from 2008 that the idea of amending what was then the practice was intended to be shifted, that the change that the police have now identified some 8 or 9 months ago was not intended. And that's a fair comment, but has equally, the point has already been made elsewhere as well, that there is equally no evidence that there was no such intention. And I'll come back to that point in a moment. The general proposition agreed to is that IP should be retained in the event of a conviction. And clearly that is the practice at the district court and indeed at the youth court if a young person against whom a charge is found proven is sent to the district court for sentencing. I think we need to reflect for a while on why the Children, Young Persons and Their Families Act specifically uses language other than the language of conviction. If we look at the section of the SIFS Act related to Section 283, there is reference to conviction in some of the higher order responses that are possible under that section. By that I mean some of the more serious responses in the event a young person having been found guilty of some crime or some criminal offence, some offending. It's proposed that certain forfeiture of property, for example, may be applied if the young person...
Order. I'm sorry to interrupt the member. It's increasingly difficult to hear the member, and I'd ask if you want to have conversations to go out to the lobbies. David Clendon.
Thank you, Mr. Chair. In the context of this Section 283, there are 2 or 3 references made to penalties that might be applied to the young person as if the young person were an adult and had been convicted of that offence by a district court. And I think we need to reflect on that. As we said earlier, the deal breaker, the point at which the 2008 legislation fell over and created this conundrum for the police and indeed for the House rests on the definition of that word conviction. And I would ask people who have been in this House longer than I have, why was it that when the Child, Young Person and Their Families Act was being drafted, that there was specific exclusion, that the notion of conviction to the largest extent possible was removed from the youth court? I think it's a reasonable proposition that there has been a deliberate attempt made to remove the language of conviction, to take away that status of a convicted person, shall we say, from young people. Rather, the charge can be found, an order can be made against them. I think we need to consider why that language is so specific and why there was such pains taken to take away the notion of convicting a young person for an offence, except at the very highest level, those purely indictable offences, those which are carrying something like a 10-year sentence conceivably. Clearly there is a difference between dealing with young people and dealing with adults. The relatively, I could call it an arbitrary cut-off point of 17 or 18 years has been the point of distinction. We could contemplate that, but I think for the moment sufficient to acknowledge the point that we do treat young people differently. That is an aspect of our contemporary law. It was not evidence in the 1958 Act, to which there has been some reference made already in this debate. Mr. Speaker. Mr. Chair.
David Clendon.
Mr. Chair, I think we need to acknowledge that in 1958 there was no clear distinction made in law between a person and a young person. I say that willing to be corrected, but certainly on the very brief amount of research we've been able to do this morning, we have been unable to find in that earlier legislation from some 50 or more years ago distinctions between a person in law and a young person. And we have moved on from that, and I think it is a good thing. Clearly we ought not to treat children or very young people as if they had the judgmental abilities, the ability to distinguish what is sensible and good action, as we wouldn't sensibly require them to meet the same standards as an adult. And I think there are very sound reasons why we have changed this language. And 50 years on from 1958, we have acknowledged that young people are different. They are subject, particularly in this modern era, to very different pressures, very different expectations, very different... they are growing up in a very different world than were their peers in the 50s and 60s. And I think we do need to seriously reflect on that when we consider perhaps, dare I say it, that perhaps the legislation passed in 2008 that this bill seeks to amend, maybe we did the right thing by accident, by excluding young children, the convictions, the penalties imposed at the youth court from this question of whether or not we retained the youth IP. So I would just simply choose to... It would be helpful, I think, if the Minister did take a call in this committee stage and respond to some very good questions, I think, that were posed from Labor speakers earlier in relation to the history of some of this, and simply to reflect on the matter of why it is that we so carefully and deliberately avoided the notion of convicting young people. A conviction in the adult context does enable police to retain IP of an adult offender. In this, by accident, we have now a situation where young people do not have that same penalty opposed to them. I'd be very interested to hear from the Minister, and I do hope she'll take a call.
Jamie Lee Ross.
I move that the question be now